All right, good evening. It is 5:30 and I'm going to call a virtual special meeting to order. The purpose of this special meeting is an executive session for approximately 30 minutes to discuss complaints or charges against a board member and to discuss with legal counsel representing the district litigation or potential litigation to which the district is likely to become a party.
Thank you, President Daniels, members of the board, Ms. Santello, Ms. Halley. Curtis, I'm going to turn it over to you to begin the proceedings for this evening.
Wait, are we going into, we have to leave? Yeah, we have.
Absolutely. Thank you.
Okay.
Thank you, Ms. Santello. I appreciate that. We're set up. Thank you.
All right. All right. I'd like to call our virtual special meeting to order. And at this time, we have one item of business. So at this time, I'll call for a motion to approve consent agenda item 2.01, legal representation for defense against recall charges for board directors. Is there a motion?
I make a motion to support recall efforts to support board directors.
Is that appropriate, Curtis?
I didn't know I could, I
I'm
have to
asking-
abstain from a vote, so I don't know if I can make the
That's why I
motion.
just asked him. Yeah. Is
Right.
that appropriate? Okay,
As a board member, she can make the vote,
okay, awesome.
make the
Is
motion.
there a second?
I'll second it for discussion.
It's been moved and seconded. Is there discussion? I think this might be a good time to kind of explain what Director Ringadasalam was asking about.
And
Yeah,
so
I think
good
it's
evening to-
important for the, sorry, go ahead, Curtis.
So if you want to go ahead, Director Vengadaswalam, and I can explain a little bit of the law once you're done.
Yes, Mr. Leonard, I just want to make sure the public is aware of what exactly we're voting for today and what the implications are in terms of the public funds expended for this. Thank you.
All right, thank you, Director, and good evening to the board, Dr. Watts, Ms. Santello. What we are really voting on here is a request from Vice President Bettinger and Director Hamada, a request to pay for cost of defense in a recall petition, which is outlined in law. And the law is found in RCW 4.96.041. And what this basically allows is that if recall petitions or claims are brought against directors or other public officials, they can request that public funds be used for a defense. And I can understand any apprehension or worry from the public or from the board as to whether or not this is appropriate. But the law outlines when it is appropriate. And the key factor is whether or not the actions being alleged are within the scope of the job of a board director. My legal opinion is I've looked at the recall petition, I've reviewed it, and I believe that the actions being alleged are within the scope of their duties as board directors. This is consistent with our legal positioning for any employee in the district, whether they be a board director, whether they be a bus driver, whether they be a teacher. If someone is sued while doing a good faith job, their good faith job in their job, they shouldn't have to get their own attorney. And in those circumstances, the government entity can approve and request and approve payment of that defense. And that is what's before you. You've had two board directors that have requested it. In my role as board counsel, I have reviewed the request and believe it to be in the scope. And in reviewing the law, it says if it's within the scope, the request shall be granted. And in my review, I believe it to be within the scope. But ultimately, the legislative authority of the local government entity, i.e. the board, would take action. And that's what's before you now. And so that's a quick explanation of RCW 4.96.041 as to why we're here and why action would be required by the board. I can certainly answer any questions you have, or we can continue our discussion before taking the vote.
And this action would approve representation for the June, is it 7th or 8th? So the one proceeding, is that right?
That is correct. So what is before the board right now is a sufficiency petition of the petition of the recall petition, which will be a hearing to determine whether or not the petition as drafted is sufficient. There could be arguments made in a hearing, and I would anticipate the hearing would probably be about an hour in which arguments will be presented. There might also be briefing made, meaning briefs submitted to the county arguing why the petition is not sufficient. And it's possible that at that stage, the petition could be dismissed. And so the question becomes, should the government entity provide the defense for that, or should board directors be on their own for providing their defense or not having counsel? In my reading of the law, the request is appropriate, and if it's within the scope, that can be appropriately before the board. To your question, President Daniels, I believe that this is not a significant legal process. It's a sufficiency challenge. It's a basic threshold question. Does it meet the basic requirements to survive sufficiency? It's an hour hearing and some briefing. I don't think it's it's not a trial. It's meant to be a truncated and short legal proceeding in which a decision will be rendered.
And so if it were to continue after that, so let's say it were to be found sufficient and were to move forward, would we be obligated to continue to provide that defense, or would it have to come back to the board for other discussion to move forward?
It may. The board would still have the right. The statute says the expenses paid may include cost associated with an appeal to Superior Court. Absent that, the sufficiency challenge or the appeal to the Superior Court, everything else would be outside of the purview of this, if that makes sense. So at that point, once it's past the sufficiency stage and it goes to the vote and we look at the votes, I don't anticipate that there would be any other legal action required by the board or by board attorney or anyone else. There's no real action to be taken at that point.
Thank you, Mr. Leonard. Other discussion?
And for clarity, Mr. Leonard, as we discussed, Director Hamada and I might have separate legal representation, or we might have the same. And I would need guidance on finding legal representation, honestly. Is that correct?
Yes.
It might be separate.
Vice President Bettinger, you can. And we can talk about that. In my role as board attorney, I do not represent individual board members. And I would feel I would have a potential conflict in doing so. I do not represent individuals in this capacity. I am the board attorney. And while I am recommending that counsel can be secured in this, I'm not looking to be counsel of record.
Any other discussion? And also for clarity, Vice President Bettinger and Director Hamada will not be participating in this vote. All right, hearing none. All of those in favor of approving agenda item 2.0, legal representation for defense against recall charges for board directors, please indicate by raising your right hand and saying aye. Aye.
Aye.
All those opposed, say no. Any abstentions? Motion carries. I'm sorry. Oh, yeah.
I think we have to abstain.
I thought you were recused from the vote, period.
Okay.
So, all right. So it's been moved and approved. The motion passes. This concludes our virtual special meeting. We are now adjourned. Thank you.
Thank you.